welcome to our second webinar of 2025. This morning's webinar is on the economic abuse of older people and will focus on coerced debt and the misuse of lasting power of attorney. My name is Sarah Brown and I'm the Vice Chair of Hourglass. And for anyone who's not familiar with our charity, Hourglass is a UK-wide charity focused on ending the abuse, harm and exploitation of older people. And our mission is to create a safer ageing society where older people are valued and where they can grow old safely, free from abuse. It is estimated that around 2.7 million older people experience some form of abuse, harm or exploitation or neglect in the UK every year. And with an ageing population, that figure is set to rise. Economic abuse is sadly the most common form of abuse reported to our 24/7 helpline, with over a third of all calls mentioning economic abuse. It can take many forms, from misusing bank cards, stolen pensions, coerced loans, to being manipulated into handing over finances or property. Our recent report, The Economics of Abuse, highlighted the scale of this problem in the UK, and it is estimated that we find that older victim survivors of abuse lost an estimated 53 million to economic abuse in the last 3 years. And those are only the figures that we have from cases reported to ourselves. This figure is likely to be only a fraction of the true cost, as many cases, as you can imagine, go unreported. A significant number of these cases involve the misuse of lasting power of attorney. The scale of this problem is growing, with data showing that the number of referrals and investigations into abuse by attorneys has increased by 28% between 2022-23 and 2023-24. It is also worrying that public awareness is limited, with recent Hourglass polling finding that 24% of people did not see using a lasting power of attorney over an older relative for personal financial gain was an abusive act. In this morning's webinar, we will discuss the prevalence and scale of economic abuse with our panel of experts and what changes are needed to safeguard older people. But before I introduce our panelists to you this morning, just some housekeeping rules. This morning's webinar is being recorded and will be sent to everyone who is registered for the webinar after the event. So please do share the recording with family, friends and colleagues who maybe haven't been able to join us this morning. The recording will also be uploaded onto our Hourglass Knowledge Bank and on our YouTube platform. After this morning's webinar, delegates will be sent a short SurveyMonkey evaluation, and we would ask you to take a few minutes to complete the evaluation, as we really do value and appreciate feedback so that we can use that feedback to improve future events. And if you haven't already done so, please sign up for our Hourglass newsletter and follow us on our socials. And please do feel free to comment. We like to get feedback from everything that we are posting on our social. Please also take the oath, pledging your support to end abuse of older people by 2050. And Penny will pop the link to taking the oath into the chat box. And we have just announced that our next conference, which will be on the 12th of November in Edinburgh, and tickets for that conference have just gone on sale. Early bird tickets at a discounted price have gone on sale this week. So please consider that to join us at our annual conference. And finally, if you have any questions during this morning's webinar, please use the question and answer function, and we will try to get round and answer all of the questions that are put into the question and answer box this morning. So I'm delighted to introduce to you this morning our panelists. We have with us this morning Fabian Hamilton, Member of Parliament, and Fabian will introduce himself in a few minutes and the work that he's been doing on his private member's bill. We have Professor Roy Anderson from University of Essex, who is an applied health services researcher, and again Rob will do is a bit of introduction in a few minutes. And we have Ian Cranfield, who is a dispute resolution solicitor and one of our trustees on the board of Hourglass. And we have Louise Lewis, who's the National Head of Trusts, Estates and Tax at her team at her law firm, and has a lot of experience working with STEP, and I know Louise will explain that to you. I would now like to invite our panelists to introduce themselves and perhaps just give us a bit of their background and experience of working with victim survivors of economic abuse. And after that, we will have a facilitated conversation with some questions. But as I said, if as we go along, there are questions that you would particularly like the panel to address, please do put those into the question and answer box. Thank you. So if we could maybe just start with a quick round of introductions and if I just go through in the same order. Fabian, if you'd like to start.
Thank you very much, Sarah. Good morning, everybody. My name's Fabian Hamilton. I'm very grateful to you for being invited to this event this morning. And I apologise that I have to leave after 1 hour in order to return back to my constituency. I'm the Labour MP for Leeds North East. I was first elected in 1997 when I had black hair and a black beard. I've now served 28 years for the constituents of North East Leeds and obviously in Parliament itself. This issue came to my attention about 6-7 years ago now, when a constituent approached me regarding the issue of predatory marriage. This was when a younger person usually marries somebody much older than themselves in the hope that as soon as they die, their entire estate will be inherited by the new spouse, because a marriage, as most people don't realize, remarriage actually invalidates and nullifies an existing will. So unless you remake your will, automatically your worldly possessions are left to your new spouse. And because of that ignorance, a lot of people have exploited it, not a lot, but a few unscrupulous individuals. Out of that arose the abuse of lasting power of attorney. And I tabled my bill last November. I'll explain the rules later, Sarah. And I'm hoping that that will now progress through the Houses of Parliament, both the Commons and the Lords, and become law eventually.
Thanks, Fabian. Rob, if we pass over to you.
Sure. Hello, everyone. Yes, I feel very privileged to be part of this panel. Although I have the word professor in front of my name, I think I'm primarily here as an expert by experience. So I have a close relative who was affected by the abuse of their power of attorney. And I guess also I'm an expert in the research sense, in the near complete absence of research about this particular aspect of abuse, but also elder abuse more generally is hugely hidden problem, partly because the data on it aren't as strong or current as they should be. And so I've recently launched a webpage and blog about abuse by LPA attorneys, and that's to both share understanding about it, but also ultimately, hopefully, to prevent it. While I firmly believe there's a need for much better and more research about abuse by LPA attorneys, I think there's also some initial work to do with just sharing stories. And there are even barriers to that in terms of people knowing that they're not alone fundamentally, but also seeking advice and getting support from other people who have been affected by it. And I guess that's in common with lots of other forms of abuse, where in the moment of realizing what's happening, you don't know who to turn to, and you don't know that actually you're suffering from something that lots of other people have been through before. So yes. And by the way, just I'm at the University of Exeter, not Essex.
Oh, sorry. Apologies. I had you worried there. Thanks, Rob. Ian, if we move across to you.
Good morning, everybody. What a privilege it is to be here this morning, helping to present this seminar. My name is Ian Cranefield. I'm a consultant solicitor, which means I'm basically self-employed. I work on my own, but I work with a firm in Nottingham called Richard Nelson LLP. I qualified in 1995, and I've been associated with Hourglass and the charity, as it used to be called, Action on Elder Abuse, since the early 2000s, really. And I kind of fell into this area of practice of trying to remedy through the civil courts the invidious presence of financial abuse amongst older and vulnerable people. A lot of the work that I do is in the court of protection, which a lot of people don't fully understand. It's a jurisdiction which makes decisions on behalf of people who lack the mental capacity to make those particular decisions. And the court, will often come to visibility in the press if a very young child with terminal cancer, for example, if there's a disagreement between mum and dad who are separated about whether or not someone should receive experimental treatment abroad to try and save their life, that will often hit the headlines. And the court is making these sorts of decisions, and decisions about financial abuse, and decisions about the appointment or revocation of attorneys, day in, day out, but a lot of it is unseen. And a lot of it's very private, because the people at the center of the story, the person lacking capacity, has not consented to be part of the litigation. It's happening around them. So, with good reason, these things are, to a great degree, private. Difficulty with that is getting people and the general public to understand what's going on and what may happen if someone that they care for or love finds themselves in this situation. And it's interesting, just very quickly, what Rob says about his personal experience, because whenever I talk about this subject at a networking event or amongst other professionals, people don't really need to ask me about the law I do. They just often come to me and say, I'm worried about a neighbor, I'm worried about my aunt, I'm worried about my grandmother. So it's something which many people have a personal connection with.
Thanks, Ian. And Louise.
Thank you very much. Likewise, I'm absolutely delighted to have been invited today. Thank you very much for having me. Like Ian, I am a lawyer by trade. I'm a solicitor. I qualified in 2005, so I've been doing this coming up to 20 years now. My area of practice is actually quite similar to what Ian was just describing. So we do a lot of work in the Court of Protection, and particularly my firm is what's called a panel deputy. So we are referred cases by the court when family members or other people, attorneys or deputies, are actually removed by the court. And then we have to take on management of people's affairs, look at whether financial and other abuse has occurred, and look to rectify that. So we have direct experience of this day in, day out. Also, I sort of do the other end, where I do estate planning for individual people before we get to that point. And in that capacity, I've had several cases of financial abuse across my desk, the worst of which was mentioned in an article that went out this week in This Is Money, where we actually had an attorney who was prosecuted, and we were able to prove £80,000 worth of money had been taken by her unlawfully. So we see this, and we see it more commonly now. It's happening much, much more often. And the abuse of powers of attorney is something that's really at the forefront of people's minds in the legal profession if you're acting in this field. So my other hat is that I am a member of, within the legal profession, we have something called the Society of Trust and Estate Practitioners. They have various special interest groups, one of which is mental capacity. So it's basically lawyers around the world who specialise in looking after people who have a disability or kind of mental capacity issue. And I was formerly the deputy chair of that. So I've spoken at conferences on predatory marriage and financial abuse, amongst other things. So thank you for having me.
Thanks, Louise. And just keeping an eye on the chat. And before we move on, Rob, I don't know whether you've picked it up, but someone is asking if you could post the link to your blog on the chat function or whatever.
Absolutely. Yeah, I'll do that now. Sure.
That's great, thank you. And another question that has come in just to keep on top of the questions, and it's maybe one, Louise, because you've mentioned it, was around, can a person with dementia and who has no capacity have a power of attorney or a lasting power of attorney? And can this be contested?
Yes, it can be contested. So if someone has capacity, and there's a sort of 4-stage process to determining what capacity actually is, I don't know if it's worth me very briefly explaining what that is, but in order to have capacity under what's called the Mental Capacity Act 2005, a person has to be able to take in information, weigh up the information, so making a decision, to weigh up the pros and cons of any particular situation, make a decision based on that weighing up exercise, and then communicate their decision back. And that's how we judge capacity. So if a person has capacity, they can sign a power of attorney. If unfortunately they have lost capacity, and normally it's a medical professional who will make that decision, that they can't sign a power of attorney, but someone can apply to the Court of Protection for what's called deputyship. It used to be called receivership. So rather than having an attorney who you would choose yourself, the court will appoint someone for you. And the benefit of that system really is that there's much more regulation. So the court will oversee the deputies, they have to submit annual accounts. There's much more oversight on what a deputy is doing, whereas a power of attorney or an attorney acting under a power doesn't necessarily have to do any of that.
Okay, thanks, Louise, for clarifying that. And Fabian, a question that you may have seen coming in, and before I come to you just to ask you to explain a little bit about your private members bill. Someone is asking, knowing what an important document the lasting power of attorney is, why has the government enabled people and possibly abusers of vulnerable adults the option of completing a lasting power of attorney online with no checks or safeguards?
That is an extremely good question, and that goes to the heart of why I'm doing what I'm doing. Let me first explain how the mechanism works, because it is quite opaque and it's quite complex. The government broadly controls the time on the floor of the House of Commons. So for a backbench member like me, even in the governing party, to introduce a piece of legislation, it is quite difficult to find the time. So I used a mechanism called a 10-minute rule bill. And that is granted to any MP who applies, but it's quite difficult to get. So I had to book it well in advance. And you get literally 10 minutes to speak on the first reading of a bill that you want to introduce, and explaining why you want to introduce it. You have the floor of the House, and anybody who opposes that has 10 minutes to oppose it. Now, the broad protocol is that you introduce non-party political issues. So the protection against the abuse of lasting power of attorney is clearly a non-partisan issue, something that all MPs should sign up to. So I got MPs from right across the House, and I have to name them when I introduce the bill at first reading. But at first reading, it's just the title of the bill. Once that's agreed by the House, then the officials in an office called the Public Bill Office drafts the bill according to what you've actually said on the floor of the House and in consultation with the individual member. So I now actually have a bill called, and I've got a copy of it here, which is quite interesting, right in front of me, called the Powers of Attorney Bill. And then that goes to second reading. Second reading, again, because time is restricted, is quite hard to get. So I'm scheduled for second reading in June. Now, if I do get that second reading slot, and there's a lot of competition for these time slots, then as long as it's passed by the House of Commons by majority or without any opposition, it can then go on to the remaining stages. That is a committee stage, a report stage, and a third reading stage. This is not a controversial bill, but I think the questioner goes to the heart of why we need it. And that actually is reflected in the comments I made on the floor of the House about the Office of the Public Guardian. Now, if this sounds like something out of Charles Dickens, it's probably because it is like something out of Charles Dickens, together with the Court of Protection, of course, which again sounds like a chapter of Bleak House by Charles Dickens, if anybody remembers that. And so these organisations should be directly accountable. Now, the Court of Protection does incredibly good work, but it's underfunded, and there's a long waiting list, as I'm sure our solicitors Louise and Ian and Rob obviously would attest. But the Office of the Public Guardian is an arm's length government body run by civil servants, and its mission statement says that it's there to ensure that it balances its books, that the revenue it receives from all the activities it conducts matches the expenditure. Now, I think that's entirely on its head. Of course, it's important for these bodies to be financially viable, but much more importantly, is the protection of vulnerable people, especially older people. And that is where I was deeply critical of the OPG on the floor of the House of Commons. And Sarah, I think it's shocking to me and to everybody that's following this story that the Office of the Public Guardian, since November, and it's now 4 months ago, has never been in touch with an MP, i.e. myself, who was deeply critical of what they did and the way they did it. Now, you're right, that questioner is right about making it's being made even easier to get a lasting power of attorney online. What I'm asking for, and my bill is quite detailed, and I don't know if this is the moment to just briefly read you the main parts of it. There are 8 clauses, if you like. They're one sentence each, Sarah, but it'll give people listening to this a very clear idea of what we're asking for. The first is the duties of, stop me if I'm going on too long, the duties of banks in respect of lasting powers of attorney. So the bill actually places duties on banks to make sure they do due diligence when somebody walks into a bank with an LPA certificate and says, I want to open a new account and transfer the entire contents of this person's account into my bank account. And if that sounds far-fetched, it isn't, because that's the most obvious and clearest and most common form of abuse amongst the many others. The second is the powers of the Public Guardian in relation to investigations. What has been happening with the Office of the Public Guardian is that people complaining about abuse of LPAs have either not been listened to or have been put on a list that is so long that it never gets investigated. And I think it's only 25% of reported cases of abuse of LPAs have actually been investigated. That is not good enough. The third is to review the effectiveness of the powers of the Office of the Public Guardian. That goes along with the previous clause. The fourth is the duties of care homes in respect of lasting powers of attorney. Very often, unscrupulous individuals, and there was a case of a solicitor, I have to say a bent solicitor, and there aren't many of them, who I won't name, but was named by Sue Mitchell in her podcast on the BBC recently. I think it's called The Will Detectives. Extremely good piece of work. This individual has actually holds something like 150 different powers of attorney for different individuals. That should not be allowed, and we aim to stop that in this bill. Care homes have a duty not to allow this kind of abuse to take place, and that's what we will put on them. The next one is requirement for the Public Guardian to notify a donor's general practitioner. Amazingly and staggeringly, that doesn't happen at the moment. It's not a requirement of the Office of the Public Guardian to notify a GP for the individual, for the donor of the power of attorney. The requirement for attorneys to notify a death of a donor, believe it or not, attorneys at the moment under lasting power of attorney do not have a duty to notify the authorities of the death of a donor. I find that staggering, and that will be in my bill and become law, I hope. The next one is requirement for the public guardian to take steps to promote a search facility. Now, if this sounds slightly strange, it's not, because what's important is for individual family members and close relatives and even close friends to find out if an individual has given power of attorney. It's almost impossible, as our legal experts will attest, to actually find out the information. It's called the OPG 100. And we want to really expand that so that it's a live search facility, not one that you have to search each day and hope that somebody's lodged their power of attorney that day. And if they've lodged it yesterday, it won't be on today's list. That's a complete nonsense. And the final one is the extent, that's it actually, it's 7. So the final clause is actually the extent, commencement and the short title of the bill. So that's just a technical issue. So we've got those 7 clauses, which we think, and I think, will actually make sure that this is tightened up and that the rules are much clearer and that therefore abuse is far less likely. Forgive me for talking so long about this. It's a long process.
It is. And we, as you know, our Glass as a charity are very much 100% behind you, Fabian, in pushing through your private members bill, because it is so important, you know. And you've just, highlighted very briefly the main areas, but I think even from the short time we've been on this webinar, the number of questions coming in terms of people asking very pertinent questions. One, I think, Ian, that has come in that maybe I could give to you is someone is asking if an attorney and with a lasting power of attorney abuses their powers and then takes whatever money is available and then revokes the lasting power of attorney, is there anything that can be done about that? And the delegate posting that in is saying that the police informed them that actually it wasn't considered to be fraud because they said they were spending the money as they saw fit. But obviously,
Sure. Well, this is a very common situation, and it's one that infuriates me a lot. I mean, there is some good news and there's some bad news. The good news is that attorneys are in what the lawyers call a fiduciary position, which means a position of utmost trust and confidence. And usually in a situation like this, if someone makes an allegation against somebody else, they need to prove the allegation that they've made in the civil law on the balance of probabilities. They need to establish, they have the burden of establishing that it's more likely than not that someone has been dishonest. And in the police setting, of course, the police need to be able to prove effectively beyond all reasonable doubt that someone has been dishonest. The good news, which is worth, make the entire seminar just worthwhile just for this, is that there is a presumption in law of undue influence if, firstly, someone is in a position of trust and confidence, and secondly, they have received money direct from somebody else, the donor, and that it demands an explanation. It's somewhat inexplicable why that has happened. So that is the equivalent of you being arrested by the police and told to explain why you didn't do the burglary. So it's a fundamental shift, what we call a reversal of the burden of proof. That's called presumed undue influence. Now, what is frustrating is that people don't realize this, and a number of times that I've engaged with a deviant attorney, and I've said, this money has gone missing on this particular date, it's gone to you, what are you going to do about it? And they'll say, you'll never prove it. And I'll say, I don't have to. There is a presumption that you've exercised undue influence because of your position of trust and confidence, unless you can demonstrate otherwise. So there's a lot more to this, but it's a really powerful tool. The second thing, so if they've revoked the power of attorney, then whoever then takes responsibility for the vulnerable person, it might be the vulnerable person themselves if they've still got capacity. They can appoint another attorney or do something themselves. Or if they lack capacity, it could be a deputy who could step in and try and recover this money from the deviant attorney. But the second point to make is about the police. There is, believe it or not, an offence which absolutely fits what we're talking about, which is fraud by abuse of position, which is Section 4 of the Fraud Act 2006. But the police, more often than not, don't enforce it because they have a different understanding, a different approach, and a poor level of training about mental capacity. Their view is that someone has effectively opened the door to someone, they've opened their wallet to somebody else, and that person is free to dip in and out if they want, and they can't establish that it's dishonest. Whereas most of these offences are sufficiently serious for them to be jury trials at the Crown Court. And the jury is ordinary men and women, just like us, who can establish for themselves whether someone's actions have been dishonest. And all they need to demonstrate is that they have been placed into a position of power and influence where honesty is expected of them. And now my argument with the police is always that the police are halfway there already. And as long as you can establish that what they did was dishonest, that fell outside the remit of what an attorney should be doing in the best interests of the person that they are representing, then it should be relatively straightforward to prove that someone has abused their position of trust. But the police mentality is very, very different. And I think we've got a lot of work to do before we can be positive and we have the assurance that the police are going to act in the way that we expect.
Thank you, and that's very helpful. In fact, one of the delegates has mentioned that, saying that from their experience, the standard of police knowledge and investigations is poor, and financial abuse of the elderly is not seen as a priority. And I think that's something that we just have to continue to work on, and with Fabian's private member bill, raise the profile and raise awareness of just the extent of this problem. We're still there's been quite a few questions have come in about deputy bonds, and someone is asking why bonds aren't mandatory for LPAs. And I don't know whether anyone, Louise, whether that's something that you would.
It's something we have certainly looked at. So I mentioned that I am within the Society of Trust and Estates Practitioners. We actually have a campaign at the moment called Spot the Signs, and we've been going out consulting with all our members about various different ways that we can put more protections in place. So, for example, one of the ways was to say, well, all attorneys should be regulated in the same way as deputies. You know, they should have to submit accounts, etc. And if that's the case, it's not a stretch to go to then every attorney should have a deputy bond as well. And a deputy bond, for those who don't know, is basically like an insurance policy, so that money can be called in if money is lost on behalf of someone who's lost mental capacity. So it's certainly something that we have been talking about within the legal profession. It hasn't come in yet. It's not something that's been made mandatory, but that would be a solution to provide some protection for people, definitely. But, you know, it's difficult. So if you have a look at the campaign, you know, it's that sort of, at the moment, we're saying to people, there's very practical advice about keeping in touch with people, making sure that, you know, that there are other people who can step in, not just the police. We have social services, but we know that all state agencies are very understaffed. It's very difficult in terms of their caseloads. So yeah, I think there's a lot of financial abuse that's still going under the radar, unfortunately.
Yeah, thanks, Louise. Okay, we'll move on to some of our sort of general questions. And for the first one, maybe Rob, if I come to you first. How do issues like loneliness, cognitive decline, or family dependency create conditions where abuse is more likely to occur? And what can be done to address these root causes?
Thanks, Sarah. I mean, if I first sort of tell the story briefly of my close relative who was subject to abuse by their LPA attorney, it's only in hindsight that we realised that he was subtly coerced into changing his power of attorney choices and plans. And I think it would take somebody quite skilled and well trained at that time to have worked out that they'd had a recent diagnosis of a life-limiting condition. And so there was a lot of fear about the future. There was also a degree of dependency on the person who was ultimately made their attorney. So I guess the main thing to say is that a lot of these things go together and it's very hard to disentangle them. It's also very hard to spot them in the moment. And often it's only in hindsight that you join the dots and realize how, I mean, I think vulnerability to manipulation and coercion is a hugely complex human area of science and just how things like abuse unfold. I know that STEP did a large survey amongst all their members just over a year ago, and I thought it was fascinating how isolation and vulnerability is just not a black and white thing. I think the government and research funding bodies are very aware that social isolation is bad for all sorts of reasons, and there are initiatives in various ways, intergenerational programs to try and tackle that. But some of these other vulnerabilities that can occur within families, I think it's really tricky. I was going to say, in relation to Fabian's summary of his bill, one of the things that the bill can't tackle, but I know Fabian and his team are aware of, is the issue that in England and Wales, you do not need a professional certificate provider for creating a lasting power of attorney. And what this means is you can have somebody who signs and enables the processing and registration of your power of attorney who has just known you for 2 years or more. That's it could be a neighbor, it could be somebody else who has abusive intentions. Whereas in Scotland and in other jurisdictions, you actually have to have somebody who, importantly, is trained in assessing mental capacity. Does the person know what they're doing by creating this legal instrument? And secondly, who has the skills to ask these important questions that might detect if somebody is not making this decision or not choosing who to be their attorney of their own free will. So yeah, I don't think there are any simple answers to the whole web of factors that can make somebody vulnerable. But I think there does need to be a broader understanding of it, and hopefully eventually that will be factored into the processes of how people create power of attorney.
Thanks, Rob. Ian, is there anything you'd like to add?
There is actually, very much so. Just very briefly, I'd just like to highlight completely from a non-legal perspective, but a practical perspective of what we often deal with in these cases on a day-by-day basis. You've got someone who is at a vulnerable point in their life, but has often been the reason, one of the reasons they're a financial target for dishonesty may be because they have quite a lot of money, because they maybe have been quite successful in life, run a business or a part of a family company or whatever. They will be proud people that don't want to admit that they are less capable than they once were. They might have, I mean, a lot of the people that I've ended up representing or doing cases about are recently bereaved older men who have been married to the same person for 60 years and get crushingly lonely really, really quickly, and turn to companionship from their cleaner or from someone they advertise for, like a professional companion. I've had cases where people have paid £45,000 a year salary to have someone in the house with them who spends most of their time using their professional gym membership that they've been given, and effectively is paid to become a more insidious influence in this person's life. And they may be in denial of their own decline, which is understandable because they're proud people. They're dignified people. And they might be easily persuaded that their overprotective family are being overprotective of their money. And all it takes is a false narrative from someone who is close to them to change this and say, well, the only reason your family don't like me, Alfred, is because they're after your money. They've never taken an interest before in you, Alfred, until I turned up, because they're jealous of my close relationship with you, Alfred. And this kind of stoking the fires of division is so easy if you're an abuser with a voice of control. And often these people who are very wealthy, they've got family relationships where their family maybe live abroad or live a long distance away, and it's difficult to keep in touch very regularly. Whereas if the abuser is someone who lives locally, they become the preeminent voice in their life. And you can just see how this comes. It's the kind of grooming that we are really familiar with children, but we don't want to accept that it happens with older, vulnerable people. And the other point that I would make, which picks up on what Rob is saying, is that when these things are investigated by social services, they will often be very binary in their approach to it. They'll say someone's got capacity, they can make some unwise choices, they can decide who to have contact with. If other people don't like it, that's their tough. If they've got capacity, they're not part of our problem. If they lack capacity, then we can intervene, we can intercede, we can provide support. And most of us will have elderly relatives who are something in between, people whose perspectives on life have narrowed, people who now value companionship and support more significantly than they do money. And so we have a situation where people's vulnerabilities are comprehensive, but they're still potentially capable, and therefore they don't have the protection of social services in the way that we might expect.
Yeah. Thanks, Ian. I think that is very true. My next question, and Fabian, I'll come to you first on this. Why do you think economic abuse is the most common form of abuse reported to us on the Hourglass helpline? And what does this tell us about the experiences of older people?
So something I've been pondering for a long time, Sarah. I think the more I see, the more cases I hear, the more shocking stories that are told to me through championing this particular issue. It becomes clear to me that one of the drivers, not the only driver, is the increasing inequality in our society. Now, you'd expect somebody on the left like me to say that, but let's just look carefully at the way wealth has changed in its distribution. When I was growing up in the 60s and 70s, we didn't live in such a wealthy society, but we certainly lived in a more equal one. Now you have extremes of wealth and, I'm afraid, extremes of poverty. And that can be a driver. If people in the same family see an elderly relative who, Ian has just described a lot of those issues really clearly, and that's my experience too. Somebody who's quite well off by comparison with the rest of the family, but is extremely lonely, then they become the targets for unscrupulous individuals. And we saw that with predatory marriage, which is nowhere near as common as the abuse of lasting power of attorney. So I think that we need the safeguards, of course we do, but we need to address some of the root causes. And that's not to take away the lifelong comfort and wealth that people have worked so hard for. That's not what I'm suggesting for 1 minute. But I do think that it's important that people in work are rewarded for the work that they do, and that our public services are the great equalizer in our society. Because as long as they're properly funded, which they clearly aren't at the moment, then those services are available to everybody, whether they're wealthy, poor, middle income, doesn't matter. And if you look at countries where those public services work effectively and efficiently, I'm thinking of Norway, Sweden, Denmark, some of the Scandinavian countries, you find that that you don't eliminate abuse, but you actually tend to minimize it because people have access to what everybody else has access to. Doesn't stop individuals who are greedy or wicked from trying to rob their nearest and dearest because they're jealous of what they've got. That will never go away. But I think we can minimize it by addressing the causes of inequality in our society. And I have to say worldwide too. I do a lot of international work. So that's my sort of political lecture there. I'm sorry about that to everybody, but I think if you look around you, you'll see there's a lot of truth in what I've said.
Yeah, absolutely, Fabian. Okay, there's loads of chat going on in the chat box and question and answers. And can I just say to delegates, we will go through all of the questions, and I know people are asking for links and information, and we'll respond to those after the webinar this morning if people are looking for particular information. And I know Fabian has replied in the chat box as well. So we will obviously go through. I'm just trying to pick out sort of things as we go through the general questions and some sort of affiliated questions that are coming in the chat box. So my next question, and Louise, I'll come to you to start this question off. In your opinion, what changes, both legal, institutional or cultural, do you think would make the biggest difference in reducing the economic abuse against older people? And what cases of financial abuse have you encountered in practice, and how were they resolved?
Yeah, thank you, Sarah. Perhaps if I deal with the cases first, as I mentioned at the outset, because we are a panel deputy, we do get, so it's sort of day to day, we have a team here dealing with this all the time. So they can be as simple as accidental abuse of power of attorney. And what I mean by that is under Section 12 of the Mental Capacity Act, for example, an attorney can make certain gifts on behalf of the person who's lost capacity, but they are restricted. So it's sort of reasonable gifts in comparison with the size of the person's estate and if the person would have made that gift themselves. So, for example, you find cases where people have, paid for meals out or taken gifts that were probably too large, that the donor wouldn't have done themselves. So that sort of thing can happen, and that's relatively easy to rectify, and that most of the time you can get that money back, so you can take civil action to recoup that money. The worst cases I've seen are probably what I've referenced before. So there are two that sort of spring to mind. One is the case where we were actually acting for the person who lost capacity during her lifetime. We were her deputy, and we were her deputy because her niece was removed from her position as attorney because somebody discovered that she was actually taking money. And we think well, we were able to prove £80,000 was definitely taken by the attorney and spent on herself. We think it could have been up to £120,000. And then the way that we rectified that was eventually the lady, the donor who'd had money stolen from her, died. And through the estate, we were able to sort of reduce the share that was passing to the attorney to compensate the other beneficiary. So in essence, the lady who died had left some money to the attorney who'd stolen from her, and we were able to take that money out of her share that she was inheriting from the estate. Otherwise, you can take certain civil action. The more sort of insidious cases that I think Ian referenced are the ones where it's quite difficult. You know something's off, you know something's not quite right, but you can't quite put your finger on it. So to give an example of that, we had a case with a lady who, exactly as Ian said, she inherited a lot of money from her sister, and she was quite wealthy in her own right. And we actually were her attorney, so she'd appointed us as her attorney before she lost capacity. And all of a sudden, this person appeared in her life who she'd met through an organisation called U3A, a sort of social club. And this person started contacting us and saying that our client wanted to change her power of attorney to appoint that person rather than us. And we went out to see our client, and this person just wouldn't let us see her on her own. And we had to actually have her removed from the room at one point. And our client said, under no circumstances did I want to change my power of attorney. That didn't come from me. So we were able to sort of swoop in and protect her. But I think quite often this flies under the radar because there's no regulation. So as I mentioned earlier, I think what will eventually have to happen if this is a growing problem, and clearly it is that there will have to be some sort of state regulation of attorneys, which is the obvious answer, in the same way as deputies. You know, there's a very famous High Court judge who said he was very happy, in fact, sorry, he was a Court of Protection judge, who said he would rather have a deputyship because he knew that the court would oversee what the deputy was doing, and refused to sign a power of attorney because he just said it's too open to abuse. The issue, of course, is that we know when these cases arise, either the person is reported to social services, the police, and/or the Office of the Public Guardian, all of which are, you know, extremely busy. And we know that the OPG, the Office of the Public Guardian, is overwhelmed currently at the moment. And I don't mean that in a derogatory way. They're doing their best, but they don't have enough staff to cope with what they've got. But I think that there would have to be some sort of regulation oversight of what attorneys are doing, in the same way as we have with deputyships.
Okay, thanks, Louise. That's very useful. I'm mindful, Fabian, that you need to leave us shortly to get back to your constituency. So just this question, and then any final comments you want to make before you have to leave us. Do you think there's enough awareness amongst older people and their families about what a lasting power of attorney really is and how to safeguard it from misuse?
Short answer is no, there isn't. That doesn't mean to say that more information would protect from the abusers, who are quite clever and subtle in the way they do things. But I think there are some basic safeguards that need to be put in place, which my bill will do. But no, people aren't well informed enough, and we need a campaign of public information. The work you're doing, Sarah, if I may, is absolutely superb and really important.
Thank you, Fabian. And any closing remarks you'd like to make before you?
Yes, I just say this, that I'm grateful to Hourglass for their support of my bill. Private members' bills rarely become law, and therefore we have to find other means to ensure that what we're trying to achieve actually does get onto the statute books. And one way of doing that, if you're in the governing party, is to persuade your ministerial colleagues that this is a priority and should be included in legislation that the government's introducing, maybe as an addendum or an addition to that legislation. So with that in mind, I'm meeting Sarah Sackman, who's my parliamentary colleague, a member for Finchley and Golders Green, and she's one of the law officers of the current government. I think she's Solicitor General. And so I will be meeting her in the next few weeks, to actually sooner than that, I think the next few days, to talk about exactly how what I'm trying to achieve can be done by the government, and that will ensure that it actually happens. So we're not just relying on parliamentary, on the sort of bizarre and rather opaque procedures in Parliament, I am lobbying directly. And I see no reason why the current government, or indeed any other government actually, should not accede to these requests and incorporate what I and my colleagues are trying to do in making the law much stronger and putting the safeguards in place that we really, really need to ensure that we end as far as we can this shocking and horrific abuse of older people. I could carry on with some of the cases that I've heard over the last few months and years, which have shocked me, and I see a lot of awful things from day to day. But I won't do that now because we don't have time. And as you rightly said, I've got to rush to get on my bike, literally to get on my bike actually, to cycle to King's Cross Station. So thank you once again for inviting me. It has been a privilege to be with you, and especially to hear the experts, Ian, Louise, and Rob, from whom I've learned quite a lot today. And I wouldn't mind seeing you outside of this forum to discuss what we're trying to do in Parliament and seek some of your advice and guidance, if that's possible. I think, Sarah, you've got my contact details.
Yeah, we have an hourglass, certainly. And a massive thank you, Fabian, for taking the time. I appreciate just how busy you are, but we were delighted that you accepted the invitation to join the panel. And we look forward to following how your private members' bill proceeds through Westminster.
Thank you, Sarah. Please keep in touch, because your work, your support, and your members are absolutely crucial to what I'm trying to do in Parliament. So I just thank you very much for everything you're doing.
Thanks, Fabian. Take care.
Forgive me. Bye for now.
Bye. Okay, so moving on, and the next question, and there are absolutely loads. I'm sort of distracted because there's so much coming in the chat function. And as I said earlier, please be assured that we will go through all of the questions and respond to people afterwards if we haven't been able to answer the question or to provide the information or the links that people need. We will follow up after this morning's webinar with all of you. Rob, coming to you, lasting power of attorney is supposed to protect individuals who need help to manage their affairs. Where do you see the main systems failing, and how this leads to misuse?
Thanks for giving me the opportunity. I mean, the short answer is, where do I start? I think there's all sorts of levels, and to some extent, Fabian's bill is trying to tackle some of the key ones. I've mentioned the other one to do with the weak provisions there are in the UK at the moment to do with certificate providers, because, is it Martin Lewis, Money Supermarket Man, says, this is in some ways a more important and powerful decision that people make than even their will, in terms of the substantial powers it gives to people. But what I might add, and it's something we haven't talked about yet, is banks. So I found it astonishing when we finally got the evidence and saw the blatant transactions from my relative's accounts straight into the attorney's account. And you'd think in this day of AI or other tools that we know banks use to monitor whether fraud might be taking place, that they could set in place all sorts of things to just, doesn't necessarily mean that somebody's doing something very bad, but it could lead to a prompt where they get a message that says, do you have evidence that this is in your donor's best interest, or things like that. So I think there's a lot of scope for banks to be, and bank staff to be, better trained and more knowledgeable about understanding and checking the authenticity of power of attorney agreements. But also after the effect, one of the big catch-22s, if you like, that's been alluded to so far, is that a lot of power of attorney abuse does not come to light until after the donor has died. And even that is in those, you could say, fortunate situations where the executors of the will are different people to the attorney. when the attorney is also the executor of the will, I think it's extremely unlikely that financial abuse would come to light. But even in those cases, banks, and certainly the bank I had to deal with, were very poorly aware of the information rights of executors. They had really shoddy record keeping of who had increased a standing order from this amount to this amount to this. So I think there's a lot of really fundamental work that has to go on alongside Fabian's bill in working with banks so that they are much better equipped, both technologically and in terms of staff training, in protecting LPA donors. Because at the moment, I don't know, it'd be interesting to hear Ian and Louise's views on the key things that they think banks could easily and should be doing to better protect donors from potentially abusive attorneys.
Thanks, Rob. Louise, do you want to comment on that in terms of what perhaps banks and other financial institutions could be doing?
Yeah, of course. Sorry, Ian, were you going to comment first? No, okay. So it's really interesting, isn't it? Because banks are so patchy. I have found in practice that banks have been pretty good in our experience in terms of picking up fraud, and actually they've been one of the key ways that we've been notified of things when things are going wrong. I guess, so there is, one of the things that STEP has been involved in was I was working with a professor at Oxford University who's working with big AI companies to track and trace large transactions or things that look unusual. And it was to start helping people, not just elderly people, but people with any kind of mental disability, so that unusual transactions could be flagged quite easily using technological solutions, and then the customer would be notified. I think the fall down there is that if the customer doesn't have capacity, the bank won't necessarily know who then to notify. And so the bank has to have its own procedures about, okay, in that situation, do we then go to social services? Do we have a duty to go to the police? Who are we notifying? How far do we go? And so a lot of it, I suppose, would fall back to social services and or the police, and it would have to be the bank's own risk management systems that would pick that up. But in our experience, they've been pretty good to date. I don't know if Ian, you have a different experience at all.
I think your use of the word patchy is bang on the money, really. Some are good, some are less good. The banks have extensive duties to report suspicious activities to the Serious Organised Crime Agency, and they probably do that a lot more diligently and seriously than they do financial abuse. We've all been in that situation where we've been abroad on holiday, we've gone to pay for a meal, and the card's been declined because some piece of software has picked up on the fact that that our card is being used somewhere different. And we're kind of amazed that, after a quick phone call that can be released, and, the software already exists. It just needs to have the parameters set in a way which is more sensitive to the sorts of financial transactions that we're talking about, I think. I mean, one way is to place additional duties, a bit like Fabian's bill is seeking to do. But another, I think, would be, and we've discussed this on a previous webinar with Hourglass, was for banks to actually get ahead commercially and think, well, we could actually create a fee-paying account with additional protection measures, which we could make either optional or mandatory for attorneys. So maybe it's got better enhanced software. Maybe it's got pre-set thresholds for money to be spent in a month. There are so many things that could be done, and the banks there could be a fee-paying account, so the banks actually make some money out of it through providing something that was a little bit more foolproof. Well, it's not rocket science. They're just, and there are certain banks that are really ahead of the game and have produced, evidence that they are really focused on this, and others just will not change until they're compelled to change. One thing that crosses a number of these questions that we've got, which is a particular bugbear of mine, is that people say they're attorneys, and banks, doctors, social workers, other third parties just simply accept that fact. And there's no kind of identity document that the attorney can produce which demonstrates that fact. They can sometimes produce the power of attorney itself, but that sometimes contains some private information about, that's unique to the donor. So I think effectively every time someone says that they're an attorney, they should be able to produce some kind of an extract from the OPG register, which contains information like, does the donor, has the OPG been notified that the donor lacks capacity, for example, on it? When was the date of the power of attorney executed? When was the date that it was registered? What's, if there are more than one attorneys, contact details for the other attorney, so that this can be, because there are plenty of powers of attorney where one is very passive and one is very active. And I think again, there's a simple change that could be made so that people simply do not accept that someone can take these far-reaching steps without seeing evidence that's from an official document that's extracted from the register, and the owner shouldn't be on the third party trying to extract that information from the OPG register themselves.
Okay, thanks, Ian. Rob, anything, I know you're inputting into the webinar chat, anything you want to add to that in terms of the comment that you've made that you had heard that from other solicitors that some fraud detection checks are actually turned off by banks?
Well, yeah, that was in a meeting with other people affected by this problem that Fabian convened, actually. And so I don't know how true it is, and it probably just links to Louise and Ian's point that different banks have got very different patchy sort of ways of monitoring and checking these things. I would say that from my perspective, there are certain types of transactions that I can't believe would be hard to specify. For example, when an attorney sets up a new joint bank account with their donor and then moves lots of money from the donor's bank account into that joint bank account, that's a classic, like, absolutely black and white way that they will inherit by survivorship the funds in the joint bank account. And so there are certain transactions which are just by definition not in the best interests of the donor. And so I just think there should be really serious red flags for a certain number of things that directly contravene their duties. Obviously there's legal and other kind of terms and conditions things that might make that trickier than I imagine, but yeah, that's some of the things we discovered about the person who financially abused my close relative. I was truly astonished that there wasn't any kind of trigger or banking, and I guess this is a part of the secrecy, is that attorneys also have a duty of confidentiality. So they've got, as well as the powers to take money almost invisibly, they kind of have the power to be really secretive about that information as well. So it's, but hopefully some banking regulations and further checks could make this less common, or at least add additional steps and checks.
Thanks, Rob. Yeah, there's, lots coming in the chat function in terms of people's experience running up against difficulties with banks and the responses that they get. So I think it's clearly an area, and it's probably, as someone said, the response from the financial institutions is patchy, and people have had less than good experience. Just mindful that we're coming towards the end of the seminar, and we've still a few areas to cover. Louise, I'll come to you with this question. What does the Mental Capacity Act say about the scope of powers given to attorneys? Because I know that was a particular area of interest that you have.
Yeah, so broadly speaking, so I think most people know that sort of basics of it. So you have the power of attorney for health and welfare, and you have the power of attorney for finance. The health and welfare one can only be used if you have lost mental capacity, because those are very, very personal care decisions. That's entirely separate. Whereas the finance one, you have a choice as to whether you turn it on at the point that you lose capacity, or whether it can be used from the moment that it's registered with the Office of the Public Guardian. And most of my clients tend to go with as soon as it's registered, because there may be situations where you are physically incapacitated, but mentally well, but you just need a bit of help doing certain things. So broadly speaking, the attorney can step into the donor's shoes, but there are restrictions in the Mental Capacity Act. So for example, there are certain restrictions around you can't consent to marriage on behalf of somebody else, you can't vote for them, for example. But the big one I mentioned before is around that ability to make gifts, which is in section 12. So really, I think that's where a lot of attorneys come unstuck, is you can only really make the gifts that are reasonable in comparison with the donor's estate, and looking at whether that is something that they would have done themselves. So sort of typical Christmas and birthday gifts, those sorts of things. And so it's really important for attorneys to be educated about the extent of their powers. And it can be accidental. As I said, abuse can happen by accident rather than by design or intention. And if that's the case, that's very easy to rectify normally, but it absolutely can happen. I think the other thing to say is that there is a lot of information on the OPG website and on STEP's website. So there is a lot about what attorneys can and can't do. And that, always happy to help people if needed. We can always take extra questions afterwards if needed, but ultimately there's a lot of information in the public domain, and there has been case law at the Court of Protection that says that ignorance of the law isn't an excuse. So if somebody does do something that exceeds their powers, i.e. makes large gifts without court consent, then the court takes a very, very dim view on that. Court of Protection does.
Okay, thanks, Louise. Ian, anything that you want to add to that?
I think one of the scope of powers, and this is slightly deviating from economic abuse, but it dovetails with isolation, which is at the root cause of kind of coercive control and so on, is that I've seen a number of examples under health and welfare powers of attorney where attorneys have sought to shut down contact between the donor who's lost capacity to decide most things for themselves and other family members. And it's absolutely astonishing, I think, that the law allows that. I've had a situation where someone's partner has been placed into a care home, and the family have refused to tell him where she's gone. And they were separated for 11 months. Now, the family didn't get on with each other. And I get that, it's a reality for a lot of families, but it does not justify the severance of a relationship arbitrarily, which is effectively what was going on. And that's taken a lot of time, a lot of cost to repair. And I've seen this a number of times. So I think, for example, attorneys might have emergency powers. If someone was at risk of domestic abuse from their partner, for example, it might be perfectly sensible for the children who are also attorneys under health and welfare power of attorney to say, well, we want to suspend visits for a period of time. But I think after that kind of initial period, maybe, a few weeks or something, it should really come down to a court order to determine whether that sort of absolute prohibition on contact with the rest of your family forever becomes, because that is about as far reaching as you can get. And so it's economic abuse is the more prevalent sort, but this kind of often inter-family, inter-sibling rivalry about control is a really serious problem as well, I think.
Yeah, and that is coming through in the chat function as well. Rob, if I can come to you with the next question. Do the current safeguarding frameworks allow for early intervention when concerns about attorneys are raised? And I know I've seen in the chat function a number of the delegates, obviously, who work within adult safeguarding are reporting that they're often frustrated that whilst they might have instinctively feel that things aren't as they should be, but perhaps don't meet the threshold for intervention, either through adult safeguarding or by police intervention. So it is obviously something people do come across, that actually they have concerns, but they're not quite sure where they take those concerns.
Yeah, I'm not sure I'm best placed to advise on this. Unfortunately, it'll be quite a pessimistic view. I have discovered through my own experiences, and it is reflected in a small survey that I conducted with Carolyn Stevens and others that I've posted the link to in the chat. Unfortunately, the OPG, it does have a fairly restricted jurisdiction about what it can investigate, but I think it takes an even more narrow interpretation of that. And so, for example, the fact that so many different types of abuse occur together, and the fact that the LPA attorney is always in the strongest position to hide, to cover their tracks, in terms of the nature of their abuse, I think that means that the OPG should take note of, if you like, circumstantial evidence of other types of abuse. And when Fabian Hamilton brought together probably the largest group of people at that time who had been affected by this problem, the issue that Ian just mentioned to do with enforced isolation and that the abusive attorney was finding ways to separate the family. In Carolyn Stevens' father's case, I mean, this has been covered a lot in the BBC News, moved her father away and didn't share at all where her father had gone. So he was essentially abducted. And so I do think that the OPG should have much broader investigatory powers, so that it's not just direct evidence of economic abuse or direct evidence of physical abuse, which triggers enough evidence to investigate. There can clearly be patterns and clues of other types of abuse, which surely should make a strong suspicion of economic abuse also taking place. And so I think the way the OPG currently prioritizes its investigations is very, very opaque, and often leads to them referring people who have strong suspicions to either seek help from the police or social services, where there can be other things that let them down. You know, there's some pie charts on that blog that show that 3/4 of people who contacted the OPG found it either somewhat unhelpful or very unhelpful, the proportions aren't much more favourable for adult social services and police. So I think people have a very hard time trying to get the support and advice that they need, even if they've got really quite strong personal testimony of witnessing things that they may not recognise at the time are abuse, but in hindsight they realise actually this kind of forced isolation or coercive control, it's abuse. And so I think it's partly that the people who experience this are experiencing it for the first time, perhaps haven't come across somebody who is that manipulative, and it's really challenging to piece together what's going on.
Okay, thanks, Rob. Moving on, Ian, if I come to you with this next question. When an attorney is removed due to safeguarding concerns, should there be an automatic referral to police to investigate possible economic abuse?
I wouldn't necessarily say automatic, because it all depends on what the circumstances are. It's usually their conduct before or during their role as attorney which is causing them to be removed. If it's financially orientated, it usually has to be serious enough to justify a reasonable suspicion investigation by the police. It may well not end up being sufficiently higher threshold of evidence to justify a prosecution. That's fair enough. But I think, judges do have the power to refer matters of concern to the police, matters of concern to regulators, and I think it should almost be automatic in most cases. And yeah, it's just a question of what the police do with it once they receive it, because they have a hard job and a high threshold of proof to pursue. But I think it's all about mindset, like Rob has identified. It's, where there's a will, there's a way. And I see this sometimes in social services as well. I think social services and social workers have a terrifically hard job. And they are under-resourced and overpressed and so on. But in the absence of, for example, a statutory right, as we tried to get into the Care Act but failed, but a statutory right to have to interview a vulnerable person on their own, in their own home, to get beyond the threshold of the doorkeeper of the front door. That's what we tried to with Action on Elder Abuse, as it then was. We tried to campaign for that with the Care Act, and it was just deemed to be a step too far. But in Scotland and other jurisdictions, they don't tend to use this. They just can say to people at the doorway, we can do this the easy way or the hard way. We can come in and see the vulnerable person that we're worried about with your consent, or we can get a court order. Now, 99% of people, especially if the social worker is standing next to someone in a police uniform, with the message that sends, would say, all right, then, so be it. That doesn't mean you've even used the powers in the legislation. You don't need to. You just need to be able to have some gravitas and some clout to say, this is going to happen whether you like it or not. And then it happens. So I think, or for example, when social workers are doing a financial assessment to see whether someone is going to require some financial support going into a care home, they might pick up on the fact that there are some strange transactions in the bank statements they're looking at. Well, they need to be brave enough to overturn some stones and see and explore that a little bit further. And if they discover something and they're not quite sure whether they can gain access to the abuser and the abused person, why not utilize something that's going to appeal to the abuser, such as the possibility of financial support, the possibility of aids and equipment, the possibility of additional state benefits. That's potentially going to be a way in to to get more information from the abuser by appealing to precisely the greed that has got them into that situation in the first place. But you need to think creatively. You need to think collaboratively with the police, with healthcare, and so on. I know this happens in multi-agency safeguarding hubs, but it needs to happen more. People need to do each other favors and get the job done, because we all know this where suspicions need to be investigated.
Okay, thanks, Ian. Just before we close the webinar, just a couple of questions around, and obviously we've been talking largely about misuse of lasting power of attorney and situations where that's raised. But looking at coerced debt, Louise, if I could maybe come to you, what barriers do older people face when trying to report or recover coerced debt? And are there any particular financial or legal protections that are missing?
So I was just going to pick up on something that Ian just said, actually. It goes back to the whole point about state regulation. So the visiting, this is sort of relevant to the question, actually, having people visit someone to see what's actually going on. To my mind, it's completely the wrong way round, in that if we have a deputyship, which is already then, we already have state intervention, and we have somebody with oversight in terms of the deputies having to submit accounts, etc. The Court of Protection will insist that there is a Court of Protection visitor come out and see that person. And yet when you have an attorney appointed, that's not the case. And so there's no reason why attorneys should be treated any differently. So having some sort of system of visitation in the same way as we have with deputyships would help to try and start weeding a lot of this out quicker as well. In terms of coerced debt, I think it's similar to what I said about gifting, in the sense that we can take civil action to recover. If someone doesn't have capacity and they've entered into some sort of a debt arrangement, loan agreement, whatever that is, mortgage, equity release, and they didn't have capacity, then we can completely undo that contract. If we were able to prove that they didn't have capacity, that contract should not be valid. And there's action that we can take to sort of negotiate with the lender, and then obviously civil action against the person who's entered into the contract, i.e. the attorney.
Okay, thanks, Louise. And someone is just asking, how do people go about getting a deputy? Yeah, so this is the court process. So if you have lost capacity and you don't have a power of attorney in place, then anyone can apply for deputyship. So it will typically be a family member, but it doesn't have to be. It's anyone who can apply. It can be a friend, professional. There's a whole court process that has to be overseen in terms of assessment of the person's capacity. So there has to be a medical assessment that the person has lost capacity. We have to submit lots of information about the person, what we know about their finances. Crucially, as part of the application process, people have to be given notice. So for example, if we're applying for deputyship for welfare, so someone's lost capacity and we're applying for welfare powers over that person, we'll give notice to social services normally and the person's doctor. So there's a lot more safeguards in that system than there is in the power of attorney system. Okay, thanks, Louise, for clarifying that. Well, we've actually probably just come up to time, but just doing a quick round for any final comments our panelists would like to make, and starting with you, Rob, is there anything as we close this morning's webinar that you would like to?
No, it's been really fascinating, not just hearing from Ian and Louise, but also reading some of the interesting, challenging questions in the chat. So thank you for having me.
Yeah, and thank you. Ian?
Yeah, I'm just an advocate for constructive, positive change. So I think we've reached a surfeit of complaining about things are not being good enough, but we need to come up with good creative ideas as to how to make those positive changes. And and I think that's beginning to happen with Fabian's bill, with the studies that are coming out. And I think we're gradually getting to the point where people are talking about this more openly and realizing the extent of the problem. So that's a positive thing.
Thanks, Ian. And Louise, any final comments?
Yeah, thank you. It was just to say again quickly about the Spot the Signs campaign for STEP. If you have a look on their website, and it's simple things, you know, like somebody becoming more withdrawn. You know, I think it's really important to start looking out for each other. But thank you ever so much for having me. You're doing a wonderful job, Hourglass. So thank you.
Thanks, Louise. And it just leaves to be just for a few closing comments, just to say, because I've noticed a chat in the chat box, we will be sending a recording of this morning's webinar to everyone that is registered. So you will get that recording. And as I said earlier, please feel free to share and please complete the evaluation, because we do act on any comments and suggestions that come back in. So it just leads to me to thank Louise, Rob and Ian. It has been amazing this morning, and as folk have said, the amount of engagement from the delegates has been exceptional. We will go through all of the inputs into the chat, and those that need followed up, Hourglass will respond to those after this morning's webinar. So thank you all for your time. It has been very informative. We could go on for hours, and I'm quite sure Hourglass will come back to this subject again in future webinars. But thank you all for agreeing to be panelists with us this morning, and thank you to all our delegates for your engagement. It does make the process so much more enjoyable when people are engaged in the subject and are offering views and comments and experiences that they have been party to. So I look forward to seeing everyone at our next webinar. Good morning, everyone.
Thanks, Sarah.
Sarah.
Take care.
Thank you.